You're listening to Best Practices with Kenny Berger. On this podcast, we talk with the country's top trial lawyers about their approaches to every aspect of practice, from case selection to closing argument. Welcome. Another exciting day on the podcast. Our guest today is my now good friend, and at this point, almost old buddy, Wisconsin trial lawyer Al Foeckler. Al, welcome to the podcast.
Kenny, thanks, man. So awesome. So awesome to be on. I was really grateful when you asked me to come on.
Oh, very grateful when you agreed. You and I met at Trial Lawyers University out in Huntington Beach last year, early in the morning, sitting out on the patio, kind of looking out at the Pacific and hit it off. I think you might have been wearing maybe a hat from a South Carolina golf course or something, but we immediately had a connection.
Yeah, it was, I think because we were like East Coast and Midwest guys out on the West Coast, we were up at like the crack of dawn, right? Because of the time change. And we were both just kind of sitting out there like, yeah, we hit it off. I think I had a hat on from Kiowa, and that's what kind of opened up the conversation from the ocean course.
Yeah. And you were talking at that point, I knew a good bit about the firm. You had some great results. And I remember there was a trial that was coming up, I don't think too much later in the year. And it turns out that was a $15 million verdict in the case that we're going to be talking about today.
So that was back in June when we met at TLU. And then we tried the case at the end of October. So kind of like my whole life and conversations probably centered around that. So I'm sure I brought that case up quite a bit. I was bouncing off facts and ideas when we were talking.
I just remember being like, man, this guy's super prepared, super likable, very credible, very thoughtful, very balanced. You were talking about, and I know we're going to discuss it some of the episode, that there are multiple approaches. And in your firm, you've got an inner circle member who's been phenomenally successful, a mentor of yours, and also a number of other influences outside the firm that have all kind of helped impact your thinking on trying cases and representing people.
Yeah, so I attribute a lot of my learning and success to being mentored by Pat Dunphy. He's a member of the inner circle, and as great of a lawyer as he is, he's an even better person. I mean, he is just a really cool, awesome guy. And it's been amazing. I've worked with him now over 20 years, and he sets an amazing example. I also work with, and I tried the Wall case, we'll call it, with my partner, Brett Eckstein, who is a phenomenal lawyer, my partner, and incredibly bright, knows the law like the back of his hand, and always makes me look good. And he always cleans up my messes when I get the objection for a violation of the law during closing. He saves my butt. And he was amazing. We tried the case together. He's a great influence. But I also spend a lot of time just learning, like you said, outside of it. So big data, like I've been to Madrid and spent time with Sean and Alicia Campbell out in Madrid with Sean Claggett learning about big data. And that was a big influence on this case and how we handled it and how we moved forward with it.
And one of the questions that you had to know going into jury ball in Madrid was about to ask or not to ask, to state, to tell or not tell the jurors the number you were after in opening. So share with us what that process was like.
Yeah, actually, that was jury ball Las Vegas. So there was a second. So there was jury ball Madrid in the spring of 2005. Then I went to jury ball Vegas. It was like 3-4 weeks before the trial. It was kind of like, should I go or should I not go, just because of trial prep reasons. And when I left, we had been rehearsing my opening. So, we got the firm together and I did my opening, and there was honestly, it was a significant debate of whether I should state the value of the case. I'll say this: you don't ask for a number from the jury. You tell the jury respectfully what the value of the case is. So it's not, we're going to be asking you for X amount of dollars. It said this case is worth an X amount of dollars. So when I did my opening, I put the value in there. I said, I'm going to be asking for $40 million. And that number came from big data. Let me give you some backstory. Let me just tell you a little bit about the case too. So this case involved an 8-foot retaining wall at a senior living center where there was a senior outside smoking, sitting on her walker that had a seat on it, and the 8-foot retaining wall collapsed on top of her, buried her alive for 2 hours. She was alive. We have body cam of her being dug out by the police, just bloodied, blood dripping down her face. She's communicating. They extricate her, and she's taken to the hospital. She is awake another 2 hours. Then she's intubated. She's knocked out, intubated. So she was alive about 4 hours. So this whole case was about what are those 4 hours worth? And this case was in Ozaukee County, which is in a very, very conservative county in Wisconsin.
I'll just,
Um,
just to jump in because the question has come to my mind. So in South Carolina, we call those 4 hours the survival claim, the claim that survives
yeah.
her passing for her conscious pain and suffering, lost enjoyment of life, any damages before she lost consciousness or died. How about in Wisconsin? Can you also get damages for the wrongful death component?
Yeah, and that's an interesting wrinkle in this case, which we should talk about because Wisconsin, our wrongful death cap is $350,000.
That's horrific.
Yeah,
That's
it's
all.
terrible. I
That's
mean,
disgusting.
it's terrible, and that's collective. So here there were two adult children. They would split $350,000, 175, 175. So that
After
claim was part of the case. Okay. Right before I leave for Jury Ball Vegas, the defense files what's called an offer of judgment, basically saying we'll pay $176,000 to the son, $176,000 to the daughter. So if you add that up, that's 352, which means we could never beat that. Even if we got 350, they were willing to pay more, which means we would owe potentially some of their case costs, right? And we quickly dismissed it. We're like, well, we can't dismiss the wrongful death claim because then the kids can't testify because their feelings about losing their mom and the tears that you would have and the terrible, the good stories about the old days, none of that's relevant if we accept this. So we kind of just dismissed it and we're just like, well, however that shakes out, that shakes out. We can't give that up. So I go out to Jury Ball Vegas and I'm sitting there and it just bothered me. And I text Brett and I said, maybe we should accept it. Who's to say we're right that it would negatively affect the case if that testimony doesn't come in? I'm like, I think we should run another data study. So I walk over to John Campbell. I said, John, we've got 5 days before this offer expires. Can you run a data study quick? And since we had run one earlier, he's like, yeah, I can crank it through. We just can change some parameters. So we ran the data study at a 25 million ask and a 40 million ask with the kids' claims in there and without the kids' claims in there. Now you have to understand in Wisconsin, the cap is 350 and the jury is told that. The jury is told you can award whatever you want, but the law caps the wrongful death at 350,000. So the jury hears that number, right? So we put that in the study and the study came back, the big data study came back and said by asking 40 million and dropping the kids' claim, we had the highest win rate and our damages for the conscious pain and suffering almost doubled by getting rid of it. So
what
completely,
from what to what?
well, it was predicting an $8 million verdict and it went to 15.9 is what it was predicting.
Pretty close. Pretty
Yeah.
close.
And the verdict came down at 15 million. So it was to the point where John said, look, even if they weren't willing to pay that, just get rid of that claim because you nearly double your damages.
Yeah, if I told you I can give you 350,000, if you give me 350 Al, I'll make you 7.9.
Yeah.
I'll put all my money with you, Kenny.
Yeah. I mean, it was crazy. So we were just testing conventional wisdom with data, and thank God we did it because it literally likely doubled what we got for the pain and suffering. So that was an interesting wrinkle when you ask about the wrongful death damages. So yes, there was, but because we accepted it, the only damage item on the verdict was the pain and suffering of the estate.
Brilliant. Excellent.
That was it.
Well done.
So trying to think back because we
We're
kind of
going in and we're at this point, big data is telling us, tell them it's a lot of money.
Yeah. So big data is saying ask for $40 million. That's when you do a big data study, it tells you not only what you can expect to get if you ask a certain amount, it also gives you your expected win rate. So not everything's 100%. If you can get around 80%, above 70%, you're likely going to win the case. Our highest win rate was asking for $40 million. And you have to understand, I would bet my life no one in Ozaki County had ever asked for $40 million without big data influencing the tell of the value. Um, I probably would have been asking for $10 million, probably, and may not even gotten that high. May have been like 8 million. 4 hours, 8 million. Um, so we use big data to say, okay, we're going to do this. We're going to believe in this number. And by the time I delivered it, I 100% believed it. But the whole question was, when do you deliver the number? And I decided I was going to do it in opening. It was a big controversial thing in our firm. Huge, very controversial. Some were saying you can't do it. You haven't established your credibility yet. The jury's going to be turned off. And the other part of when I was in Vegas, not only did I talk about whether to accept the wrongful death offer, but I was asking people what we should do as far as when you should make the tell, the value of the case. Do you do an opening? And I went one morning and we were getting coffee, and right in front of me is Sean Claggett and Harry Plotkin. They're talking. So I said, Sean, Harry, here's what's going on. Should I bring up $40 million in the opening? Or do I wait till the closing to do it? And Sean, of course, is like, no, you say it as often as you can, as early as you can. Absolutely, that's what you do. And Harry's like, well, I've seen it done effectively both ways. So I start leaning towards wanting to do it. Then I was listening to another podcast with Pat Salvi was on it out of Chicago. And he was on Ravaputi. What is his podcast?
What's you love eight or
Oh, Elevate. Yeah, the Elevate podcast.
yeah.
They had Pat Salvi on, and Pat Salvi.
I mean, between Raul and Pat Salvi, I mean, two phenomenal lawyers.
No, yeah, no. And then it was Ben Gideon out out on the East Coast, so it's Ben Gideon and Raul's podcast. Pat Salvi's on, and he's talking about he tried 3 cases in a row. In 2 of the cases, he stated the value in opening, and in 1 case, he didn't. And in the 1 case he didn't, and he waited till closing to give the number, it didn't turn out as good as he wanted or thought, or as the other 2 turned out. And he talked to a juror afterwards, and the juror's like, look, I was really with you. Like, I was one of your jurors from the very beginning. But when you came in at closing and you asked for whatever the number was, I don't remember. He's like, I just was like, I thought this case was an X dollar case, and you came in at Y. And I was just like, I don't know. It just didn't seem that like a Y case. When I heard all the evidence, I thought it was an X case. And I said, you know what? That's it. I'm saying the number in opening because I think it influences how then the jurors hear and feel the evidence as it comes in. And I can tell you when the case was over, the foreperson reached out to me direct and wanted to talk. And he said, Al, I want you to know when you said in opening that the value of the case was $40 million, I had to do everything I could not to laugh out loud. He's like, but just like you said, after we heard the evidence, saw the evidence, processed the evidence, he's like, I went back into that jury room wanting to give $40 million, if not more. So that convinced me that it was the right decision to do. Now, obviously, they compromised, and the verdict came down as to a great verdict in Ozaki County of $15 million. But I don't think that happens, number one, without asking for $40 million, and number 2, without asking for it in an opening statement.
Al, when in your opening did you share the $40 million number?
Very towards the end. And it was the, what you're going to see in this case, what you're going to hear in this case. I am confident that this case is a $40 million case. And I know that number seems a lot now. I'm like, just keep an open mind. And as you hear the evidence, I'm convinced you're going to understand that this case is a $40 million case. So
even hearing you say it now, I mean, you're just, you don't feel like you're ever trying to sell me anything. I mean, your authenticity comes through, your credibility, your conviction, but not like in that conviction of you're trying to convince me. More your conviction in the sense of you know it to be true, and you believe that once I've seen the evidence, I too will know it to be true. So
yeah, and that took time to get there. Believe me, because originally I was like, oh my God, can I do this? I mean, this is a big number. But honestly, I practiced my opening so much in front of people, and I just got very comfortable with it. And obviously now looking back, I'm very convinced that that was the right number to ask for. But yeah, believing in that number when you say it is as important, if not more important than when you say it, right? I mean, ultimately that no matter when you say it, you have to truly believe in it. And that's one thing that big data did, gave me a lot of confidence in saying that number and not being afraid to say that number.
Yeah. Al, question for you. Y- Before you get to opening, what are you doing in voir dire to lay a foundation to set the stage
Yeah.
for the $40 million talent opening?
So that's an important component of it as well. And that goes back to my time at Jury Ball Vegas as well. So I'm talking to Claggett about all this and kind of getting his feedback. And he's like, look, this is what I do. In voir dire, I tie value to the burden of proof. So what I do, and this is exactly what I did in my case, I said, look, burden of proof in a case like this, a civil case, is more likely than not. We've all seen the criminal cases, but in here it's just 50.1%. Feather on the scale tips it in our favor, we win. That applies not only to liability, that also applies to damages. So let's say we've got Microsoft versus Apple, and it's $1 billion case, two huge corporations. The burden of proof in that case is more likely than not, 50.1%, put a feather on the scale. Who here would have a problem applying that scale, more likely than not, to, a corporate lawsuit, like civil lawsuit like that involving Apple and Microsoft? Anyone have a problem? No problems, right? No one raises their hands. Okay. Now let's talk about property damage claim. Let's say that the Mona Lisa goes on a tour of the world and it ends up down the road at an art gallery in Port Washington, up the road from here. And whoever puts the Mona Lisa up on the wall doesn't secure it correctly. And the Mona Lisa falls and is significantly damaged. Some people say that's a 400 million, $800 million piece of property, right? The same burden applies in that case, more likely than not. Anyone here in a property damage case involving a 400, $800 million claim, anyone have an issue applying more likely than not burden to that situation? No hands go up. I say, okay, same art gallery, okay? And a senior citizen, an older woman walks in there and is going to go see the Mona Lisa and is severely, severely injured enough that she suffers and she dies later that night from the injuries. There's some people that would say that's a 40, $50 million case, given what happened. Okay. Is there anyone here that would have a problem applying that same burden of proof when it involves an injury? So we're not talking about a corporate case, contract case between Apple and Microsoft. We're not talking about the property damage claim. We're talking about an injury to an older lady that could be 40, $50 million in value. Anyone have a problem applying that? There were some hands. There were some hands that went up, and we talked through that, not confrontationally, just tell me the issues. Okay, juror X said, yeah, I don't know. That seems like an awful lot. Anyone else believe that? Yeah, I kind of believe that. And you just get people talking about it. And that was okay. I can tell you then that when the defense got up in voir dire, one of the first things they said was, has anyone heard of what's called anchoring? So, then they said, what you just saw when the plaintiff is out there talking about $1 billion, 800 million, 40 to $50 million, that's called anchoring. And these plaintiffs' lawyers are trying to, get you to think about big numbers in cases. Does anyone here familiar with anchoring? And actually no one raised their hand. But that was their response to it when I did it. But I still think it was effective to get that number out there so that when I said it in opening, it didn't come as a surprise.
Well, let's be honest. The jurors know what you're doing.
Yeah, sure.
Okay, they're talking about big numbers. Ooh, the lawyer's talking about big numbers. Huh,
Right,
who
right.
would have thought it?
Yeah, and look, and I mean, I'm talking about a big number in the context of a woman that was trapped for 2 hours, bloodied. I mean, the medical examiner, the last witness in the case, talked about, when she palpated her face, that the bones literally moved around. That's the evidence in the case. Like, this was not a small little case. So I'm not saying that just throw a big number out there and you're going to get a great verdict. The number has to relate to the case, right? And a big number in one case may be a totally different number in a different case, but you have to embrace that big number and not walk away from it.
Yeah, I mean, for the folks listening to it, your number may be $400,000. Your number
Correct.
might be $40,000. Your
Right.
number might be $400 million.
Correct. It's
Yeah,
all relative.
one of the parts though, Al, and not to digress, but we've talked about this on the podcast before, and I think one thing I never want to be lost is you were able to tell them $40 million because of the months or years of work that had gone in to developing a $40 million case based on $40 million worth of damages, not because Al said so, but because that was the God's honest truth. That's what the evidence told.
Absolutely. And I can tell you that most lawyers, if you're not doing big data, you're not going to ask for that kind of number. I already said it. There's no way. I would not even have asked for 15. Like, there would have been money left on the table because I would have asked for maybe 10, probably 8. I would have rationalized it in my head as very conservative county, farmland, and 4 hours on the high end. Maybe they would give, 2 million, each hour, 8 million total. I could have rationalized that. That's probably the number I would have landed on without big data. Um,
Al, question for you. And the folks who are listening in South Carolina, I think will be especially interested in your answer, myself included. If you didn't have voir dire to 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 connect with the jurors, to meet the jurors, to kind of lay that foundation, would you have still put $40 million in the opening? And if
I,
so, when?
I still would have done it. Yeah, I still would have done it. I obviously prefer to be able to kind of lay the foundation in voir dire, but even if I wouldn't have been able to do that, I still think in retrospect, looking back, there was value to those jurors hearing that number and, all the evidence coming in through that filter, where because I just think that if I would have said 40 million at the end, I think then it would have backfired because I think by then people have their perception of what the case is worth. And maybe someone back there is like, oh, wow, this is a big case. I think I'd give $10 million in this case. And then you drop 40 million on them after they've had the opportunity to process the evidence themselves. I think that actually could turn them off and they would have been like, this guy's crazy. No, he's grasping, this is way out of hand, what he asked for. And I think that could have had a negative effect. So I think that my rule of thumb from now on going forward, and as much as we struggled with it, whether to ask for it or not ask for it, is going to be I'm going to ask for it. Now, there's going to be exceptions. There will absolutely be exceptions. So I'm not saying that in every single case I'm always going to ask for it, but I think the exception is going to be not saying something in opening.
Yeah. And Al, there's another thing that y'all did in opening or you did in opening with creating space and something you return to in closing. Tell us about that.
Yeah, so this comes right from Dan Ambrose, and from TLU and doing his presentation boot camp. There's a really cool part of the boot camp where he prepares witnesses, and he prepares a witness by getting that witness to like be in the space, not just describing a picture, but literally be in the 3D space and asking questions when you have that witness in that 3D space. So there's something on your left, there's something on your right, there's something behind you, as opposed to just looking at a picture. And it's a really cool way to prepare a witness to really remember something, even as simple as a car accident and what was going on in the car, right? So there's a lot of value in that. But when I was there, it was in the early stages of working on the opening for the wall collapse case. So I worked with Dan on building out the scene. So, over on this side, and you're literally, so as I'm in the courtroom looking at the jury, I'm pointing stage left, right? So to my left, the jury's right. I'm building this scene. 8-foot retaining wall is over here. There's a service door next to it. There's the garage, the big garage door, because this was an underground parking garage. So you had to come down, and that's why there were 8-foot retaining walls on each side. And this is a 3-story apartment complex. And, on this side, there were 6 apartment units. So there were 3 balconies over here, 3 balconies on the other side. There was a balcony that was sitting over the service door that created an area for people to be protected from the elements. If they'd come out that service door with the 8-foot retaining wall on one side of them, the balcony above them, that's the door that Judy came out, and she positioned her walker in that area. Now, the beauty of it was when I built out this scene, and you build it out in space with your hands mostly, and you're describing things, then you show the picture. Don't show the picture first, build it out, show the picture, and then go back to, okay, so this is the wall, this is the door. Now look at this service door. In this courtroom that we were in, there happened to be the door that the judge and the jury would come in and out of every day. That was literally the door that I built out. That was the door that Judy came through. So when I
That's
go
pretty sweet.
back in closing, I'm like, remember the scene, right? There's the wall. There's the garage. This is the door. The door you've been coming in and out of is the door that Judy came through that day with her walker. And she positions her walker right here. And we got the walker in the evidence, mangled, dirty, mangled walker that she sat in it because it had a seat. And so I took the walker and I positioned it next to the door. Now the scene that I built out in space is actually coming to life in front of them in closing, because they literally have the door that she walked through, that they've walked through. Now they're seeing where the walker is next to it, and they're envisioning this wall coming down on her. Um, and then actually in rebuttal, um, I did the man in a dark suit. I did that literally standing talking to the walker,
Mm.
like I was talking to Judy, like she was sitting there,
It
and we're great.
I'll I wanna give you another compliment here. I've thought about creating the scene and setting it with stage left, stage right, the pieces around you. Other times we've used the photograph to kind of put yourself there, but I love the way that you just taught it, which was setting the scene kind of with all 4 corners, if you will, a true three-dimensional, then showing the photo, then coming back to the scene. I love that sequence, and, kudos to Dan Ambrose, and the folks at TLU for also teaching it.
Yeah, no, and it's great because then, I mean, literally when, in opening, you set the scene, you physically are, and I'm able then to walk where I put, her, and I'm talking about, and the police, they come down the drive, they park, they walk over towards that area. So now we've got police there. They turn on their body cam. And by the way, jurors, you're going to see that body cam footage in this case. And they start pulling these bricks off of Judy. They're 82 pounds each. 82 pounds. And they're lifting, and you're going to hear, and actually, you say everything in first person. They lift these bricks, and you hear them struggling, breathing hard to lift these bricks off of her. They finally take enough bricks off of her, and you see her yellow hood of her Packers sweatshirt covering her face. And they take another brick off, and it uncovers one of her arms. And she reaches up and she pulls back her yellow hood, and she reveals her face bloodied, blood dripping down the right side of her face, her left eye swollen shut, blood dripping out of her mouth. And she says, "I saw it coming down and I couldn't move." And so you're telling this scene, openings are done. The very first piece of evidence we decide to put on in this case is the body cam footage. And that body cam footage is now showing exactly to the T of what I just described to the jury, to the T. And every word that she said, that I said they were going to hear, is stated to a T. And the credibility that you're building at that moment is amazing because there was no exaggeration. There was no overstating things. It was literally, I mean, and we were so careful. Everything we said, every word we used was going to be backed up by that video. And I think the credibility just shot through the roof.
Al, what were the defenses in this case?
So there were two parties in this case, two defendants. One was the wall builder, one was the senior living center. The senior living, so the wall builder settled out. So we were only trying against the senior living center, and the senior living center was just trying to blame it all on the wall builder.
Does the wall builder go on the verdict form?
The wall builder goes on the verdict form, and we still have to put a case in against the wall builder under Wisconsin law. Otherwise, they're able to introduce the settlement agreement into evidence to show why we changed our position. So we still had to have experts come in and talk about how terrible the wall was built. We couldn't walk away from that and focus only on the senior living center. But obviously, we're trying. So here's going back to big data again. So our big data study showed that it's incredible, man. It was crazy because the big data study came back and said 61% on the wall builder, 39% on the senior living center, and 15.9 total expected verdict. In Wisconsin, the judge reads the verdict. When the judge read the verdict, it was like hair raising. Like it was really crazy. So it was 60% wall builder, 40% senior living center, 15 million verdict. Like it was like mind blowing that it was 61% was data, 60% was the jury, 39% was data, 40% was the jury. It was crazy. And when we talked with John, he's like, look, these numbers are pretty set. He's like, maybe you could move it to 50-50, but I would be surprised if you could, but you can't do something so crazy that you lose credibility and try and push it all on the senior living center. So that was another really good point that, John Campbell gave us through big data is don't lose credibility by overreaching and trying to push too much of the percentage on senior living center.
Yeah, I've heard him call it, don't swim upstream.
Mm-hmm.
If it's clear
Yeah.
that even the jurors who are with you are going to come back at around 60-40 or at most 50-50, don't get up there and say something that's totally incredible, unbelievable, incredulous,
Right.
that would again cost you, your credibility. So
Yeah. And it all goes, I mean, look, you know this, we all know this. Credibility is everything. We can't overstate things. If you say something in an opening statement, you have to deliver. Every word you say in opening statement, you have to deliver. It can't not come up. You can't say something that is contradictory to what comes out. And you have to be credible in how you're apportioning damage, because I think generally, if not, it's going to hurt you in more than just how the damage is apportioned. It's going to hurt you in the damage number because the juries aren't going to believe you.
So Al, what did the senior care center do in terms of, I guess, some of the finger pointing toward the wall builder and to try to mitigate the damages?
Yeah, so I mean, their whole defense was the wall was built incorrectly from the beginning, and there was nothing that we could have done to know it was going to fall that day. Now, we had significant evidence, and my partner Brett did such a good job with discovery in this case and digging deep and not giving up and like having a report that had photos in it and saying, I want the underlying photos, because then he discovered more photos, like the actual like real images, and that weren't included in the report. There was a photo. So this happened in 2020. There was a photo from 2018, about 2 years, but like 18 months before the wall fell. There was a photo from, it was basically like a refinance. If you refinance your house, you have an inspection done. This was basically a refinance of a commercial property. They had an inspection done. The inspector went around, and the defense was trying to use this report to say, well, the inspector didn't find anything wrong with the wall. So Brett digs in and does a bunch of discovery, and he asks for photos that may not be in the report. And sure as shit, he gets a stack of photos, and all of a sudden I hear him start screaming down the hall, Al, get over here. And I run down there, and he shows me a photo from 2018, almost 2 years before, where you could see. So when you have a retaining wall, you're going to know this now, and you'll never look at a retaining wall the same. The way a retaining wall is built, especially a big, like 8-foot retaining wall, it leans back into what it's holding up. The retaining walls are not straight up and down. There's a slight, actually 7-degree cant or lean back into the dirt that it holds up. That's a properly built wall. Okay. What the photo in 2018, almost 2 years before this, is that the wall had moved to be vertical, and the top was slightly tilted towards the area where it fell. So we were able to show that over time the wall had moved, and our theory was they should have, number one, they should have seen it, and number two, they should have done the maintenance to prevent it from moving. So keep the grate up behind the wall, keep water from, from flowing into the back of the wall, because we had great photos of, the deterioration of, how the dirt pushed everything in the back of the wall, and that just caused the wall over time to move from canted back to vertical to being, it was just a matter of time before it flopped over.
How, one of the things that I heard that I wanted to ask about, your client was she where she was supposed to be? I mean, she was allowed to smoke cigarettes where she was?
Well, that's another interesting wrinkle. You put your finger on another interesting wrinkle in the case. So this was COVID, and the smoking area was shut down. Well, the normal smoking area was shut down, and residents were told that they had to go smoke by the street. Well, this was so they didn't. And this was a common area that residents that smoked, not smokers, residents that smoked would gather to smoke cigarettes. And in fact, we have a picture from the scene of, there was like one of those like old time coffee cans, and it literally had like butt can written on
Okay.
it.
Yep.
And they would put their cigarette butts in there. So it was common knowledge that people were going down there to smoke. But um, the defense in opening made a statement, and they never went back to it because they knew that we would have just pounced on them. They made a statement that basically, like, if it was so bad, if the wall was in such a bad, leaning so badly, that she put herself in that position by going there to smoke. Now, they never went back to that. And I reminded the jury in closing that they said that in opening statement, but they never truly went back to that. And they didn't bring that up in closing.
All right. So we get rid of the wrongful death case. Um, as far as the pain and suffering case, the pre-death pain and suffering, is there ever any testimony or any evidence about comorbidities, life expectancy? I mean, does any of that stuff come in? Is it
So
relevant?
they had a witness that was going to talk about that, and they never called that witness. They never called the witness. I think they probably realized things weren't going well, and that could have more of a negative effect than anything, because we
Did
were
the
certainly
defense,
ready.
did the defense ever give the jurors a number?
Yeah, they suggested $1 million. The other thing in this case is that I think it was around $70,000 in medical bills that we dropped. We got rid of them. The defense then tried to make an argument that they wanted to put it into evidence, and the judge said, "No, I'm not going to allow that."
You hear something crazy? That the defense can actually put in the medical bills we waive in South
Yeah,
Carolina. There's a stupid case called Nestler that goes against a lot of other opinions throughout the country, but um, they can put it in even when we waive it, which you kind of bat back and forth when they do it. But
yeah.
I think it was smart to waive it. What else? What have we? We've been talking about the case for a little bit. What have we not talked about that from a application standpoint for you in other cases, for listeners and in their cases, some takeaways and learning lessons?
I two things. Number one is practice. Number two is order of witnesses. So number one, and this was really pounded home when I was out with Ambrose. He said basically like, "What's your schedule?" And I'm like, "Well, we really don't have a schedule. You need a schedule." And we practiced the hell out of this case. Like, I think a lot of lawyers, and I've tried cases in the past where the first time the words of an opening statement that I give are those first time those words leave my mouth verbally is to the jury. I've done that in the past. You have to practice. You have to, You have to do it in front of people. You have to get feedback. You have to just get comfortable with the presentation part of it. You have to practice looking at jurors in the eyes, and you have to practice that because until I went through the trial skills training with Dan, I never realized that I think a lot of the time I'd look at the jury, but I'd almost just look at them as like a blob. So I'd be, I'd be making eye contact with quote unquote the jury, but I was not making eye contact with jurors. And until you're intentional about it, I don't think you realize, maybe there was just something that I did, but I got very intentional about truly making eye contact with people, and it takes practice to get comfortable with that, and all that practice went in. But I mean, Brett did the direct examinations of our experts. He had in twice, actually, some of our experts to come in and work on their directs. Just practice, practice, practice. You can't back off of that.
There's a
Go ahead.
quote I want to pull up real quick. I'm reading a biography on General MacArthur right now, and there's a quote in this biography. So this was after MacArthur won an appointment to West Point.
Yeah,
Reads, it was a lesson I never forget. Preparedness is the key to success and victory.
for sure. For sure. Yeah, you really got to dig in and get ready. It takes practice to do a simple thing like truly make eye contact with people. Truly make eye contact with people. It takes practice.
And your other point was on order of proof, or your order.
Yeah, so order of proof, you know, Pat Dunphy, he always suggests to us that our first witness be someone who can't really be cross-examined, right? Just get a witness on there that's nice and clean and get the momentum started. And what we did in this case, and it was so perfect the way everything played out in this case. I mean, there was looking back, I truly don't think we would have changed one thing that we did. We opened the case, and I think it was important to do this because I got up there and asked for $40 million. And our first piece of evidence in the case was playing a 25-minute body cam. So the jurors were hit damage wise with seeing her being dug out, and I think it was important not only because, like I said, it built the credibility of what I just walked through them as far as what happened. And they literally saw it play out then, not through out of my mouth, but they saw it on the video and what the body cam was shown. So we showed that body cam. Then we called one of the officers, and you can't cross-examine an officer, police officer, right? I mean, he was amazing. I mean, he was just, he was so sympathetic. Before he gets off the stand, please tell the family, I feel terrible for what happened to her. And then from there, then we moved into the liability side of it. And I was a little worried that because there were two sets of body cam video, like the 25-minute one and then the shorter, like it was like 7 minutes, 6 minutes. We played those both right away. And I'm like, maybe we should save one till the end. But it worked so great. And we got the officer on with his shorter body cam video because the other officer was retired and not available. So, we had to play both of them basically. Then we moved into liability, calling, people from the senior living center adversely, calling our experts. Then there was a phase kind of like 3/4 of the way through the case where we were calling liability witnesses, but they were kind of like also damage witnesses. So they were residents of the senior living center who we called to talk about, yeah, we saw a problem with the wall. Yeah, we reported it to management. And yeah, they didn't do anything about it. They never did anything, blah, blah, blah. But then the judge allowed us to get into, you can talk about Judy as a person and some background, right? Judy was great. Judy helped Don, who was blind, with his laundry. And, you know, the reason that we knew it was Judy who was buried was because we were walking through the hall. We saw the wall fell, and Don comes out of his apartment and says, Judy was here to do my laundry and said she'd be right back, and she never came back. And as that resident is telling, she starts crying on the stand. So now we've got her talking about liability, but now it's starting to transition to the end of the case to bring damages back into focus. Then we had two of those residents do exactly that. Then our last two witnesses was one was the emergency room doctor to talk about how Judy was failing because of her injuries, the significant injuries. And then the last witness was the incredibly graphic testimony of the medical examiner. Like I told you, palpates, feels the face, and the bones are moving underneath because her face was smashed in from it. So it was just perfect the way it was like damages, liability, damages, liability slash damages, and then damages at the end. It just really just was a perfect arc of evidence in the case to truly set the stage to give the case to the jury.
How incredible work, my friend. I knew the first time we met, you were a great guy, and I presumed you were a great lawyer, and the work you did on this case just demonstrates it. And I'm very glad the family had you and Brett and y'all's firm um, to represent Judy and give meaning to what happened to her. So well done, my friend.
I appreciate that. I appreciate that. It's kind of crazy what we do because we represent people at the lowest points of their life, and it's so important to put the work in to give them a voice, right? I mean, that's what it's truly about. And then when it turns out the right way, no matter if you give them a voice and it doesn't turn out, at least you've given them a voice, and families can appreciate that. But when the jury validates it, man, it's a truly special feeling.
That's amazing. Al, for folks who want to get in touch with you to talk about, are you barred outside Wisconsin?
No, but I will get involved in cases outside of Wisconsin or obviously in Wisconsin as well, on a pro hoc outside of Wisconsin. But you can call or text me on my mobile anytime, 414-405-7079, or my email is A and then Foeckler, last name A, F as in Frank, Oeckler at C like cat dash D like dog law.com, c-dlaw.com.
Great work. Now, when are you going to be in South Carolina next?
I don't know, we're gonna come. Well, I told you my son lives in Greenville.
Yeah.
So we're gonna come out and visit him for sure. It probably honestly won't be until May. But when we get out there, we definitely gotta meet up.
Man, I would love to. And heck, if you're down here and we got a chance to get some other members of the bar, for you to forge some of those relationships, pass on again just some of the incredible things y'all are doing, would love to make that happen too. And
Absolutely.
it's just such a blessing to have gotten to know you, and honor to have you on the podcast. You're my friend, you're one of the good ones. So
No,
thank
I could tell, man, when I met you, I'm like, this is a guy that I got a feeling we hit it off. We're gonna end up being friends. It just you just kind of know sometimes. So super, super grateful to have a South Side of Milwaukee boy on your podcast. It's pretty cool.
It's a beautiful thing, man. We've got Michael Karp coming up
Mhm.
soon. Another fella from
Carp is
Wisconsin.
great, man. He's a young guy who is really doing great things in Wisconsin, so it's exciting to see.
Yeah, and we all had a funny meal together out in Hollywood when you and I watched it playing out that we were very much not going to eat at this one restaurant when it was pouring down rain. And
Right?
then we found a rescue and
Yes.
refuge under the big sombrero and a
Yeah.
Mexican joint next door. That was a fun meal.
Good time. Good time. No, Mike Carp and his partner Bon Welsenbach, they are great people, and I am glad to see their success as well.
Yeah. All right, my friend. Ladies and gentlemen, y'all been listening to Best Practices with Kenny Berger. Our guest today is Wisconsin trial lawyer Al Foeckler. If you have anything in Wisconsin or that part of the world, or heck, you want to bring Al in on a case closer to you, ProHawk, you know where to find him. And thank y'all so much for listening. It's been fun as always, and we'll do it again soon. Take care.